Earlier, the Real News brought you reactions from outside a Baltimore courthouse that cleared Officer Edward Nero of all charges over the death of Freddie Gray.
Since the beginning of time, people of power have been killing people, poor whites, poor blacks, poor Mexicans. You get a badge and a gun, you're above the law.
Now we bring you in-depth analysis with a veteran civil rights attorney. Freddie Gray was a 25-year-old Baltimore man arrested on April 12, 2015, after running from police in West Baltimore. He died a week later, medical experts say, after suffering a fatal injury during transportation in a police wagon. This sparked weeks of mass demonstrations that only tapered off after 6 officers were charged in his death. Officer Nero was one of the 3 bike officers who took part in Gray's arrest and was charged with 4 misdemeanors: assault and misconduct in office, because prosecutors allege Nero took part in an unlawful arrest and then touched Gray without his consent. He was also charged with reckless endangerment and another misconduct charge for not seatbelting in Gray during a wagon stop where he was present. To break this all down, we spoke with veteran civil rights attorney, author, and Real News board member Dwight Pettit for his in-depth analysis of the legal theories behind the case. We started off by asking him for his reaction to the verdict.
Well, I'm a little disappointed, but not surprised, especially as to the assault charges. I felt it was going to be very difficult to establish that because police are always in a position to claim that they're acting in good faith. And if they're acting in good faith, the main question that the nation and the state, I think, are looking to, and this is the first-time prosecution, as to whether or not that can be overridden by criminal culpability. Even if you get past the legal issues of probable cause and reasonable articulable suspicion and reasonableness of their actions, even if they do not have probable cause, do not have reasonable suspicion, do not have articulable suspicion, when they're acting in good faith, can that raise the police action to criminal culpability? And I didn't think a court would go that far. I've never seen a court go that far, but for that matter, I haven't seen a state go that far to bring charges in that area.
And so the assault charge is based on the idea that this was an unjustified, it was an arrest without probable cause.
Exactly. So you have several different standards that take place. First, when you have the issue of him being chased, that's the first issue as to whether or not the chase was constitutionally correct. And the Supreme Court has said that it is. When you make eye contact in a neighborhood with high crime rate, then it raises reasonable suspicion when a person goes to flight and you can chase him. Now, get to the second part, and he's apprehended in this case. Testimony is that he gives up. So then Terry versus Ohio takes over. And Terry versus Ohio says the police officer can pat him down for his own safety and what have you for any weapons. But then after that stage passes, you have to ask, in this particular case, since Judge Williams did not let in the issue about the knife, where is the probable cause for the arrest? And so I've never seen the probable cause for the arrest. If there's no probable cause for the arrest, then the arrest is bad. And the argument of the state is then by putting him in touch with the handcuffs and bringing him down and what have you, then this amounts to an assault. And
so there's a few questions I want to ask you before we go any further. The first is talk about in the pretrial motions, Judge Barry Williams suppressed the evidence of whether that knife is illegal or not.
Mm-hmm.
What's your response to that?
Well, I don't think he ever really got to it because the state backed off of the knife. The state said, well, the knife is not going to be really relevant as to its legality or illegality because of, in fact, he's apprehended before they search him. Their argument is that he is under arrest before the search. So then the legality of the knife becomes a nullity. My understanding of the argument. So then you go from reasonable suspicion of the chase, Terry, as to the pat down, and then why is there the arrest? You don't even have to get to the knife because before you do that, you've already apprehended him. He's already under arrest. That's not to put him on the ground and handcuff him is not a Terry pat down. That's an arrest. That I believe to be the state's argument. And at that point in time, this knife becomes irrelevant. So then the question becomes, are the police acting in good faith, or as the state began to argue, well, you got to look at each case under the circumstances of that particular case, but the argument is here, considering the testimony puts him at the peripheral of everything, then where is, even in this particular case, the circumstances of this case of Nero, where is the assault?
Right,
Because he's protected by a good faith argument that he believes that the arrest is correct. Are you saying that the police officer has to go to a law book and say, okay, is this probable cause? Do I have reasonable suspicion? Do I have articulate suspicion? They're not going to put that kind of burden on the police officer.
That brings up the testimony of Garrett Miller, who was compelled to testify, and he backed the defense's argument. And so the question is, why even call him? Why even call him as a witness? I mean, it seems like it's a fair assumption that he's going to side, the defense, all these officers are coordinating their defense, and he's got immunity, so why call him? Because you can only assume he's going to back
Right,
you.
and you haven't had the chance to talk to him. You haven't had a chance to know what his testimony is. It was almost an act of desperation to some extent. Now, the opposite of that coin is, got to remember, this is only one trial out of 6. Now, as I said earlier today, what they're really playing at this point in time is the shell game. The shell game, if whether you recollect or not, is which shell is the P under. And so here you got Miller, and everybody saying, Miller taking the weight and said, I did this, I did that. Nero really didn't do anything. Okay, but what happens when it comes up to Miller's trial? It's only so many places that you can hide the P under so many shells. So at some point in time, if you argue that this is one case, one battle, not the war, that might come back to haunt him. But I have to agree with your scenario. Why call him in the first place? You already had his testimony. Anything else that you didn't ask him, or he wasn't asking his original investigatory testimony, is going to be in favor of Nero, because they're going to stick together.
Freddie Gray was arrested without probable cause. Nero was part of that arrest.
Right.
So why isn't he guilty of one of these charges, why did they drop, for example, the forcible confinement charge, and why did they not charge him with conspiracy, which is something the judge asked the prosecution? Why not charge him with
Again, that's a good question, because then they could have tied in everything that Miller did and everything that Miller testified to. And you're right. I think they seem to understand the deficiencies in the state's position in terms of false imprisonment. So they dropped that, but it's almost the same argument that comes back for the assault. That's why I never really understood the assault charge. I thought the assault charge in this particular case was the overreach.
So was there any legal basis of putting Freddie Gray in that wagon?
Well, now you're getting to a whole nother subject, because the officers who put him in the wagon, they're basically following instructions. They're following instructions from Rice, Nero, and Miller. So then you get into the issue then of whether it's reasonable or whether they acted in a reasonable manner to not follow the orders in terms of seat belting him, and whether they were aware of the medical distress that he was under, and especially with him articulating, I can't breathe, et cetera, et cetera. So that gets to the reckless endangerment, not the assault, the reckless endangerment and the misconduct. Those are separate and apart. That's why I thought that Judge Williams might find some culpability in the reckless endangerment, particularly, and also the police misconduct charge.
He mentioned, the police witnesses, they testified that Nero wasn't trained properly about the charges, so that was brought up, and his superior officers were there. The wagon driver was there, present on the scene.
Well, that goes back to shifting the P again in terms of the shell gate. They're going to shift at this point in time. They shift everything to Goodson, because Goodson is the driver. He's got the heavier charges, the second-degree murder, possibly. I'm not sure whether it's manslaughter or not, but I think he has the depraved heart.
Yeah.
And so everybody at this point in time, Miller, as well as Nero, even though he didn't testify, everybody's unloading because some of the testimony was somebody else that got in the van. And so they're saying it was somebody else's responsibility. Well, you can only push that piece so far. At some point in time, and they still got Goodson coming up for trial, so I guess they're going to attempt to unload on Goodson in terms of the reckless endangerment.
To ask you about is the significance of this prosecution. The fact that this has never been done before. So can you explain that and why it's significant? And did the prosecution jumble an opportunity to really set a precedent and stop some of these unlawful arrests that are happening across Baltimore?
Well, I think it has national implications because it's the first time that I can recall that an officer or officers are prosecuted for bad arrest. We do it in civil all the time. Constitutional claims always include false imprisonment, false arrest, et cetera, but never has criminal culpability attached, because that's usually too far of a stretch, because that's usually met by the good faith argument, as I've said before. And so how do you get to raise the criminal culpability to beyond a reasonable doubt, which is the criminal standard, when you have an officer saying, hey, I'm acting under the heat of the moment, and I am in fact acting in good faith that I believe I was making a proper arrest because I believe there was probable cause and reasonable suspicion. That's a hell of a burden to overcome. You might overcome it in a civil court where the standard is preponderance of the evidence, but how do you overcome that in terms of beyond a reasonable doubt, which is the criminal standard? Whole different ballgame.
Because if the police can just snatch up and arrest people, without reasonable cause, that's you fundamentally eroding a primary.
Right. Well, that's when the state goes back and says, when you get to that level of putting criminality in terms of the arrest conduct, then you have to look at each case as a separate entity, and then you begin to look at what did Nero do, or what actions did he take that would raise criminal culpability, even though assault is not a specific intent crime. So it's what is called general intent.
So can you explain that for the layman?
In other words, specific intent requires you to intend to the consequences of your actions. You have specific intent to assault somebody, hurt somebody, et cetera, et cetera. General intent, it's implied in the action in itself. You don't have to prove specific intent, but you've got to prove some elements which either create some type of gross negligence, which goes to the criminality, or some type of general intent to do harm, or the gross negligence to not consider your actions in terms of the reasonableness of your action in terms of the harm it's inflicted on somebody else. And so when you move from the civil to the criminal, it raises a whole different standard. But that was why the nation and FOPs nationally and FOPs locally and so forth were looking at this case, because it's the first in Maryland, but it might be one of the first in the nation where a prosecutor has tried to go that far. And remember, it's been difficult enough for a prosecutor to even charge criminally, much less to charge criminal violation for making an arrest where the officer believed that he had probable cause.
Talk about why that's important. Why is it important that a prosecutor finally, especially in a place like Baltimore, where only a third of arrests end up with charges? Why is this significant? Well,
I think it sends even though the prosecution on this one case, and we shouldn't use this one case as a blanket for everything, but in this one case, by the prosecution going forward, I think delivers a message to the police departments that it will be some accountability. There is going to be some accountability. There is the potential of some sanction if you just act boldly and arrogantly in defiance of the rights of the victim, the person being arrested. In this instance, what the court is saying, that conduct of Nero didn't arise to that level by the factual testimony that he listened to, for criminal culpability. But now that tells the police department the message that should be sent is that we do have a prosecutor in Baltimore City who will look at you and see if your actions were reasonable, or whether you, for example, knowingly knew you didn't have probable cause, knew you didn't have reasonable suspicion, and you go ahead and continue to arrest somebody, say, in a much more violent manner, in a much more comprehensive manner than Nero's relationship to Gray.
So can an officer use, so you're saying this will likely change the behavior of police officers?
I think it makes them all very, very apprehensive to a certain extent of the fact that they're just not totally immune to the rights of the individual citizen. That you do have some body of law and thought and prosecutor that will look at your actions to see whether or not you acted reasonably under the circumstances, that you, in good faith, could believe that you had probable cause, or in bad faith, you knew you did not have probable cause and then acted. That might raise it to criminal culpability.
How could this impact the other 5 cases, the other 5 officers that are being tried right now?
Well, I think it has impact in terms of strengthening the defense theory that all of these things were overcharged because of the social conditions and what was happening in Baltimore City. But I also think it allows the prosecutor or the prosecution to step back and make some very, very intelligent decisions as to where they went wrong and how they can fortify their cases, and especially how they can move in terms of what the Court of Appeals has now said is going to be dangerous grounds in terms of the immunized testimony.
Could this backfire for other, for civil rights advocates? In their view, if all these officers are found not guilty, or the majority of them are found not guilty, could this embolden police in a way?
Well, let me put it to you like this. This is nothing new. The police have been protected by the legal system for years. And we find that if you look across the board in terms of other jurisdictions, that's why I said it was a smart decision to take a judge, because the judge wasn't going to be controlled by emotion. The judge was going to be controlled by the law. But if you look at the judges across the country, when there has been judge trials, they've sided with the police. But you have to realize that's because the law, coming all the way down from the Supreme Court, right down to the states and right down to the local courts, are very, very conservative in terms of the police. And are very much, the law has evolved very much in favor of the law, of the police. And so persons like myself who've been doing police brutality cases for years, we are very aware that there is a high risk of non-success simply because it's the police, where people will tend to give the police more credit for veracity and truthfulness. The citizens want to believe the police. The law is in the favor of the police. And so if you get a judge in these particular cases, the judge is going to strictly adhere to the law. So the prosecution of the police, whether it's civil or whether it's criminal, is an uphill battle. So that hasn't changed. You can look across the country at all the acquittals, and my goodness, people talk about the cases I've won in civil court. They have no idea of the cases that I've lost in civil court. Because the Supreme Court and the Court of Appeals, Maryland, says you can't second guess the police. You can't Monday morning quarterback. You can't put into evidence what alternatives the police had. And we haven't even talked about the main defense of the police. I was in fear of my life and bodily injury. That always works. When they shoot somebody, I've had cases where people have been shot in the back. No weapons, no nothing. And the police said, I was in fear of my life. I thought he was reaching for something. Or I thought the object in his hand was a gun and it was a cell phone. Or he stopped and looked the wrong way. I thought he was going to throw a knife at me. So that defense has been working for years. And so you add the apprehension of bodily injury, you add the good faith in terms of, that's been the law in terms of search and seizures, it's also the law in terms of false arrest and what have you. So the law has always been in the favor of law enforcement. So this is no This is just one microcosm, one specter of the system, but this just steps in line with what has been historically a pattern. Not indicting Judge Williams, but he is, because he's been a prosecutor in police brutality cases out of the Department of Justice.
Right.
But he's looking at the law, and the law in itself has evolved for the protection of the police officers.